Major breaking news. The United States Supreme Court today issued their decision in the NRA versus Vulu decision. Big case, big issues, big win for the NRA and the First Amendment. 9-0, a unanimous victory for the NRA that said they had stated a claim that New York State had allegedly violated their First Amendment rights by focusing on gun-related activities and gun-related lobbying and the Second Amendment. Major win all the way around. And I'm going to tell you another particular reason which no one else has picked up on as to why this decision will be devastating to the deep state and bureaucrats across this great country that want to use regulation to thwart free speech rights in a way they would not otherwise be able to get away with. Major loss also for the Biden administration. We're going to break it all down when we come back in 1 minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the new author of a new book, guess what? Israel Disarmed, What the October 7th Attacks Teach Americans About the Right to Bear Arms. Check it out on Amazon. It's just been released. You're going to see a lot about it in the press over the next several weeks. A major discussion about how the mistakes the Israeli government made and the Israeli people made in not being properly prepared by not embracing the right to keep and bear arms the way they should have, and the consequences, the devastating consequences that they paid on October 7th when they were attacked by Hamas. A lot in that book. It's not a very long one. We'll talk more about it in future videos. But today we're going to turn to the big news, which is that the NRA won a huge aspect of its lawsuit against the state of New York in the case of NRA versus Volo or Vulu. I'm not sure how she pronounces her name. It doesn't really matter. The bottom line is, you may recall, the NRA alleged in a lawsuit that the state of New York took a series of steps after the Parkland school shooting to try to destroy all their contractual and relationships, their insurance relationships with various insurance companies and financial companies all across the state of New York. And since New York is the financial capital of the world, if you mess up people's financial and business relationships in the state of New York, you really screw them up all across the country. This is the allegation that the NRA made. The lower courts dismissed the claims by the NRA all the way up. Terrible rulings. And yet I'm happy to report that the Supreme Court, in a 9-0 unanimous decision, ruled in favor of the NRA that they had indeed stated a claim. This is something we had predicted on this channel. I said this is really a slam dunk case for the NRA before the Supreme Court. And after the oral argument, it reaffirmed that view. And 9-0 unanimous verdict, or unanimous decision, I should say, really proves the point. The bottom line legal precedent here is that the U.S. Supreme Court said that under the First Amendment and relevant First Amendment precedent, including a 1963 decision called Bantam Books versus Sullivan, we'll talk briefly about that in a minute, it reaffirms the general principle that the government or government officials cannot attempt to coerce private parties to publish or suppress views that the government disfavors without violating the First Amendment. In other words, what the government cannot do directly, it cannot kind of do indirectly in terms of punishing people for the First Amendment rights and views that the government disapproves of. The allegation is that the NRA's views in support of the Second Amendment of the right to keep and bear arms was a view that the Andrew Cuomo administration and all the bureaucrats and unelected civil servants in New York disliked, and they took certain steps to punish the NRA financially. And the Supreme Court today, in a 9-0 decision written by Justice Sonia Sotomayor, who is certainly no friend politically of the NRA, but Justice Sotomayor, I think, got this opinion because, number one, she used to sit on the U.S. Court of Appeals for the Second Circuit out in New York City. So it's appropriate that she write this decision that reverses the decision and spanks the Second Circuit Court of Appeals. She used to sit on that court. And of course, she's from New York. I think she's actually from the Bronx. And Justice Sotomayor, writing the opinion for the U.S. Supreme Court in a major First Amendment case, said, no can do. New York, your behavior, as alleged by the NRA, cannot fly. Just as a reminder, and I want to tell you why this is such a big deal. Now, it's a big deal at one level because every anti-gun newspaper in America has to say that the NRA won before the Supreme Court 9-0. They actually won even the lefty anti-gun justices. So that in and of itself is a big deal and a big win for the Second Amendment and the NRA, which is good for the Second Amendment. So all of that, yes, is 100% great, and I'm happy about it. But this decision goes further than that, and this is something you will likely only hear on this channel, or maybe you'll see some of the quotes I've given to the press on this today. Specifically, there was a major issue here, kind of an inside baseball issue that only a few people picked up on. I'm happy to report that I did pick up on it. I think we even talked about it on the channel. It was something that the Biden administration was trying to slide through past the Supreme Court. Specifically, this involved a fight over what are known as guidance letters. Guidance letters. And you're like, Mark, what the heck's a guidance letter and why do I care? Here's the game that the Biden administration and the ATF and others have been playing, and New York State tried to play it. And they tried to get this sort of approach to violating the First Amendment and to messing with people's rights by the U.S. Supreme Court, but it lost big time 9-0. Let me tell you how the game gets played and what the New York allegedly did here. Specifically, as you know, you have statutory laws that tell you what you can and cannot do. And then you have regulations that are supposed to be part of those statutes, interpreting the statutes and the regulations you have to follow. So in New York, for example, the NRA, and there are people that work with the NRA and people in the financial world, they have to comply with New York statutes, but they also have to comply with regulations. So if one of those statutes or those regulations discriminates on the basis of viewpoint of a political view or religious view, whatever it is, a viewpoint discriminatory conduct or viewpoint discriminatory act, that clearly violates the First Amendment. So what the government does, the deep state, the bureaucrats do, and New York State kind of is trying to do here, is they were trying to say that we weren't doing anything with the law or the regulations. Well, all we were doing when we were encouraging businesses such as insurance companies or banks or financial entities to reevaluate their relationship with the NRA and other gun rights organizations, we were issuing what the state of New York, considers guidance letters. And what the deep state bureaucracy in New York was trying to say is, because guidance letters only give people suggestions for good business practices, they give guidance, recommendations. They're not technically speak to the force of law. They're nothing more than recommendations and suggestions. You don't have to follow. We just think it's a good idea for you to reassess your relationship with the NRA and gun rights groups and gun companies because we think it's good business practices. We're not telling you you have to do it, but it's a good idea. Now, this was such a hot topic. It's inside baseball, but it's really important that the Biden administration sent in the Solicitor General of the United States to say two things. One is they actually said that the NRA had stated a claim and they agreed that the NRA should win the appeal before the Supreme Court. But the second thing, and the real reason why the Biden administration appeared before the Supreme Court in this case, was because they were trying to protect the games played by the bureaucrats and deep staters by using guidance letters all across the country as a way to tell people, you better behave, you better do what we say, or we're going to punish you by taking away your license, by auditing you, by doing something bad to you. So if you know what's good for you, you better do what we recommend in these guidance letters, even though, of course, the guidance letters are not legally binding. It's not the law. It's just a suggestion or hint of good business practices. But if you don't follow them, bad things will happen. It's kind of like the way organized criminals used to do. Hey, that's a nice window you got there in front of your pizza parlor. It would be terrible if something bad happened to it. So yeah, it's not a bad idea to give my buddy the trash contract in town. You get how that works. And these guidance letters by the state of New York saying that we are urging all insurance companies and banks doing business in New York to basically discontinue your relationship and arrangements with the NRA. This is essentially what the state of New York agents were allegedly doing, and guidance letters simply are not relevant to First Amendment analysis. And they specifically said that yes, guidance letters can be a factor in supporting a claim against the government under the First Amendment. So this is extremely good news, not only because the NRA won, not only because it was 9-0 and the liberals sided with all of this stuff, it also is a great decision because it's going to eliminate the possibility of government getting around viewpoint discriminatory laws by using these guidance letters, which is really a hint, nod way of saying, we recommend that you do these 3 things. Of course, if you don't, legally nothing technically will happen to you, but the reality is we will punish you, we will audit you, we will do bad things to you. And the Supreme Court said, if these guidance letters in the context of everything else that's going on show intent or are relevant to a First Amendment violation, you absolutely consider them at trial or as evidence that the First Amendment rights of somebody was violated. So let me just give you a couple quotes from the U.S. Supreme Court decision today. I think it'd be helpful for you to see some of the language from the court itself. To begin, the court said, quote, ultimately, Bantam Books, which is a great decision for the First Amendment, by the way, ultimately, Bantam Books stands for the principle that a government official cannot do indirectly what she is barred from doing directly. A government official cannot coerce a private party to punish or suppress disfavored speech on her behalf. Great quote there. Now, the other thing is they relied on this Bantam Book case. Just as a quick summary, all you need to know is that Bantam Books is a Supreme Court precedent from 1963, where basically the state of Rhode Island had set up a commission to assess whether or not certain books or publications were obscene. They weren't legally banning books in the state of Rhode Island, but they were saying that if this government commission thought that a book was obscene, they would issue an opinion suggesting that book distributors and others could be subject to legal liability if they did anything with this book, like publish it, distribute it, sell it, whatever. And the Supreme Court in 1963 said that this was simply an end run around the First Amendment, and it violated the First Amendment because basically it was an act of coercion and intimidation against private parties trying to discourage, in that case in 1963, publishers and booksellers from selling or distributing books that this commission deemed, in their opinion, to be obscene. And the Supreme Court said that violated the First Amendment. And that was the precedent of this Bantam Books versus Sullivan case that the court relied on today in the NRA. But let's go to another great quote and then we'll wrap up this video. Yet, whereas here a government official makes coercive threats in a private meeting behind closed doors, the ballot box is an especially poor check on that official's authority. Ultimately, the critical takeaway is that the First Amendment prohibits government officials from wielding their power selectively to punish or suppress speech directly or, as alleged here, through private intermediaries. All right, folks, so there you have it. Big win for the NRA, big defeat for deep state, big defeat for bureaucrats, not just anti-gun bureaucrats, but bureaucrats that want to use guidance letters and other sort of hints and suggestions for best practice as a way to intimidate their political opponents. Big win here all the way around. I'll put a link to the opinion down below, and we'll talk more about this as we carry forward. And keep in mind, of course, I'm happy to report we have my new book out, Israel Disarmed. A lot of lessons in there. We'll cover that in extensive detail in future videos. Make sure you follow me on X at 4boxesdiner. Don't forget to check out my new book, Israel Disarmed. And we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.